Good afternoon once again, ladies and gentlemen, distinguished guests. I hope we'll all be attentive. This is a difficult session when the blood has gone to assist in digestion and we can find ourselves dozing. I hope we'll not doze, because this is a very crucial part of the program. This afternoon, we are meant to have the discussion on what have we accomplished and what can we accomplish going forward. So we've had 1.5 days of discussing several challenges to family, values, to sovereignty, to our African culture, and now we are meant to be focusing on what have we accomplished and what will we accomplish going forward. For this session, I request that we all get this copy of the document that was in our folders. It's titled First African Inter-Parliamentary Conference, Communique, and Entebbe Declaration. There were 2 Entebbe declarations there that were prepared last year, and you had the communique for last year's conference. So my session is going to be very simple. I'll first have a background where I'm going to take us through, just to summarize, what was agreed last year, what did we accomplish, and then what can we do for 2024. So this is a great document. I really like even the way it has been put together. The communique was prepared as we were concluding the first conference. For those who attended in Entebbe last year, I think it was March, April of 2023. And the organizers of the conference, together with the participants, decided to do a communique, which, as you can see, is the first document. It has 42 paragraphs. And it has a long recital or preamble of numerous paragraphs. And then after that, you have the first annex, which is the Entebbe Declaration on the post-Cotonou Treaty. At that time, we were calling it post-Cotonou. The treaty had not yet been signed, and we were trying to have amendments or change before it was signed. Eventually, it was agreed by the nations of the EU and ACP that the treaty would be signed at Samoa in November last year, 15th of November, and so it has now become the Samoa Treaty. So when you see the Entebbe Declaration on the post-Cotonou agreement, it's basically the declaration on the treaty. But that time it was not yet the Samoa Treaty. And then there was a very interesting second declaration. It is the second annex, and this is the Entebbe Declaration on pornography, because pornography is one of the issues that was touched on during the first conference. And so, members, ladies and gentlemen, I want us to start by reminding ourselves, what did we agree on last year? If you look at the communique, you will notice it makes a positive reference to a number of international human rights instruments. It makes reference to the 1948 Universal Declaration of Human Rights, to the 1966 covenants, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights. It makes reference to the 1981 African Charter on Human and People's Rights. There is also reference to the 1990 African Charter on the Rights and Welfare of the Child. And there is a positive reference also to the Geneva Consensus Declaration of 2020. The year 2020 was the year when Donald Trump lost elections as President of the United States of America. They'll be having the elections in November this year. And before he lost elections, his government carried out a pro-family agenda in the international space. And one of the consequences of that is brought together several countries, about 30 countries or 26, of which more than 15 are from Africa, that together made a declaration called the Geneva Consensus Declaration on family values and of course on issues of gender rights and family values. And this consensus declaration was presented to the United Nations General Assembly in December 2020. That was the month after he lost elections. And as so happened, when the next president took office, Joe Biden, because he has carried out an agenda that is not pro-family, if I may use the most modest phrase, he decided to withdraw the United States of America from this declaration. But the declaration still exists, and the other nations have not withdrawn. And other countries in Africa are encouraged to sign on to this declaration. So there has been positive reference to those documents. And then there has been negative reference to some documents that have been generated in the recital. This is the ESA, the commitment on reproductive health services for adolescents, comprehensive sexuality education and sexual and reproductive health and services for adolescents commitment that was done in Africa, and which the pro-family forces were very unhappy about. It is not a legally binding document, but reference was made to that as a document that we need to work to dismantle. In the communique, as I said, there were about 42 paragraphs, but I want to identify the 9 key resolutions that the nations, the delegates of the last session came to, the 9 key resolutions. Just a moment. The first resolution, which is resolution number 1, was to tackle threats to national sovereignty and cultural values, which is precisely what we are doing even in this conference, to see how to advocate, to make noise, and to keep repeating the importance of national sovereignty and cultural values. And if I may just take a pause, in 1966, when the nations of the world assembled at the United Nations to discuss having operational human rights treaties, there came a split between the countries of the Western world that you could call the first world nations and the countries of the Eastern world at the time that you could call the second world nations. And the first world were insisting that human rights have to be civil and political rights. Freedom of speech, freedom of assembly, freedom to vote, right to life, freedom of religion. So they said these are the core human rights. And the nations of the East said, okay, it's very well to talk about civil and political rights, and we agree with you, but there are other set of rights that are very important. And these are the economic, social, and cultural rights. Right to food, kindly let us have some measure of silence so that we can hear. Right to food, right to education, a clean environment, right to housing. These are what we call economic, social, and cultural rights. So you then had, because of the split between the first world and the second world, they agreed to have 2 different treaties. The first one deals with what we call first generation rights, civil and political. And the second one deals with second generation human rights, economic, social, and cultural. And the newly independent African states were listening to this debate with bemusement. And for Africa, we said we accept both sets of rights, but we insisted that both declarations must include a right to self-determination. And that right to self-determination, brothers and sisters in this assembly, was actually incorporated word for word in both international covenants. Article 1 of ICCPR and Article 1 of ICESCR, they both talk about the right to self-determination, which is another way of talking about the right to sovereignty. And it mentions not just political sovereignty, but economic, social, and cultural sovereignty. So this first resolution in the communique actually aligns to a concern the African nations started expressing at the international arena from way back in 1966. In addition, when the nations of the world decided to come up with their own regional treaty instruments, the first one was the European Convention on Human Rights in 1953, the Inter-American one, then the African Charter. Only in Africa did we decide that in order to clearly identify the right to self-determination, our Charter on human rights will also include provisions on people's rights. We said it's not just the individual who has to be protected, but also peoples, including to fight against colonialism, neocolonialism, and other forms of cultural domination. So this appears in the African Charter. And this was the first key resolution of last year's communique. After that, the second is resolution number 3, to resist the sexual and reproductive health and rights agenda in international law. Resolution number 3, to resist abortion, comprehensive sexuality education, and LGBT ideology and lobby groups. Then resolution 5, to resist sexual and reproductive health and rights. Resolution 6 and 7, really I consider the fourth key resolution, which was to protect the family and natural marriage. As legislators and as the other people of Africa, to protect the family and natural marriage. The next resolution, again joint, number 9 and 10, emphasized the importance of protecting the child and also, very importantly, the rights of parents. Because in the international arena, there is kind of like a one-sided focus on protecting the rights of children and ignoring the relationship between the child and the parent. So the parents find themselves stripped of their rights and duties, which create the connection with their children. And this creates a topsy-turvy situation in international human rights sphere, in which we keep promoting children to do this, to change their sex, to have health care without the parents knowing, to have abortion, to have all kinds of things, to be educated by the state without any input by the parents, and so on. And so we insisted on this issue of the rights of the child and the rights of parents. And then there was also a key resolution, number 13, to reintroduce character-based education. That education is not just for the technical academic curriculum, but our African communities emphasized in initiation processes and other systems, character-based education. We also spoke about resolution 14, to refrain from signing or ratifying the post-Cotonou Treaty. Unfortunately, many countries that we come from have already signed the treaty. Some have not, but most of them have not ratified. So there's still room for engaging there. And then very relevant for parliamentarians, the resolution 20 to 29 jointly were asking parliamentarians to enact laws to protect the family in the different jurisdictions. And finally, resolution 41, which is the ninth one, the ninth key resolution, is to work towards development of an African protocol on family and family values, so that we have a continental-wide legal instrument recognizing the role of family. And in 1983, I think the Vatican initiated a charter on the family. And the idea is, can we borrow from them and other countries and regions that have recognized family rights and have something at the Africa level? After the communique was published, we also published the Entebbe Declaration on the Samoa Treaty, the now Samoa Treaty. And the key recommendations was, one, that the African countries to require the treaty to be restructured and or amended. So the first idea was, can we restructure this treaty? As it is currently designed, is not good for us. Number two was to decline to ratify the treaty. Now that the treaty is going forward like a train that cannot be stopped, can we conscientiously object by pulling out of the treaty? And the impact of pulling out of the ratification process would be, to the extent possible, to continue with the Cotonou framework if the treaty does not come into force by not getting the two-thirds threshold of ACP states to ratify the treaty. And we know that the EU is putting ACP states under a lot of pressure to ratify the treaty so that it can come into effect. The third recommendation was to request in each of our respective countries that the post-Cotonou treaty be debated in the parliament of each country, so that the people of Africa can have a voice and can discuss about this matter. When the nations of the European Union negotiated the Maastricht Treaty in 1992 that created the European Union, it had to be approved in each of the member states. There were debates in the respective parliaments. That is how they went in the journey towards greater integration. And so the recommendation of the declaration of Entebbe of last year was that we should require the same thing of this Samoa Treaty. It should not pass while the citizens of our respective states are unaware of the implications and the effect of the treaty. And finally, it was also recommended that the African states should consider reservations and various other mechanisms to restrict the effect of the Cotonou, post-Cotonou treaty. The last declaration was a declaration on pornography, and this one gave rise to 5 key resolutions. And again, it is Annex 2 in the same document that you have with you. The first one was to recognize pornography as a serious public health crisis. And so to apply the tools, the instruments that we apply in dealing with public health crisis to deal with pornography. The second was to make laws to prohibit comprehensive sexuality education, which tends to be explicit, bordering, or getting into pornography, and also to attack dissemination of pornography that has been spreading virtually unchecked in our countries. The third resolution was to regulate and limit pornography on the internet, apps in our mobile phones, video, etc. And it is interesting how technology, when it comes to Africa, it comes with the values and standards of those Western countries where it was developed. If in the United States of America, because of their First Amendment of free speech, they don't believe in restricting pornography, then you find their technology comes with their values and penetrates into our spaces. And only when the pornography is very obscene, violent, or child pornography do they take measures in the Western countries? Here in Africa, we hardly take measures, whether it is violent, whether it is child pornography, or even other forms of obscenity that are contrary to our laws. And I think we saw the approach to regulation that we can use when we have seen the experience with the app, these taxi hailing applications, mobile taxi hailing applications like Uber and Bolt. The various countries in Africa said, no, even though this technology has come from the West, we can regulate. We can, for example, insist that Uber must have an office in my country, that they must listen to complaints, that they must do ABC. We can pass laws. So the same approach can be taken in matters of pornography. The fourth resolution was to review the treaties and resolutions of various African Union engagements to ensure that matters of comprehensive sexuality education and pornography are not included there, and in fact are targeted for elimination. And finally, to raise awareness on the harm of pornography. This is the summary of what we did last year. And the question is, how far have we gone since last year? What is the progress we've been able to attain? So the second part of my presentation, I'm going to talk about the legislative framework that has been put in place and that can be put in place to concretize these elements of the communique and the Entebbe Declaration. And I thought of beginning by doing a very quick survey of the state of law in Africa at the moment on three issues. One, on the question of marriage and family. Number two, on the question of sexual and reproductive health and rights, that acronym or euphemism for abortion, CSE and LGBT. And thirdly, on the question of sovereignty, culture, values, and treaties. And the general situation is that there are explicit penal laws, criminal laws, criminalizing several of these things, criminalizing pornography or obscenity, criminalizing homosexual relations, criminalizing abortion in several African states, especially the states that come from the common law tradition. And the common law tradition is mainly the countries in Africa that were colonized by Britain or the United Kingdom. They follow a certain legal system called common law. And then the countries that follow the civil law system, the French-speaking countries, Portuguese-speaking countries, and so on, they follow what is called civil law system. And in the case of France, when they colonized and were leaving their colonies in Africa, the colonies were gaining independence, they of course contributed by proposing or enacting laws for the soon-to-be independent states of Africa. And they borrowed from the French Penal Code. And the French Penal Code had provision criminalizing public indecency. But it did not have provisions criminalizing homosexual activity. So you have a situation where there are several countries in Africa with explicit laws that criminalize what is called unnatural sexual activity, unnatural offenses, carnal offenses. And there are other countries in Africa without explicit laws, but where there are cultural prohibitions or rejection of homosexuality. So that generally in Africa, there is resistance to LGBT lobby and behavior and all these other things that come under the umbrella of SRHR. But In some countries it is express, in others it is not. And then there have been a few countries which over the last 10 years or 20 years or so have yielded to certain ideological pressure to change their legal systems. And of course the most dramatic is South Africa, which way back in 1996 when they passed the new constitution, their new constitution, after the end of apartheid, they included a provision outlawing discrimination on the basis of sexual orientation. So they went even beyond where many Western countries had gone at that time in 1996. And there are other countries in Southern Africa like Botswana that have been put under a lot of pressure, Zimbabwe, to follow the South African approach. So that is the situation in Africa on these issues. Explicit penal laws in some countries, cultural prohibition in others. And I want to go to some case studies very quickly about what Africa has been doing to strengthen the law. Because as lawmakers, you are very aware that the law is an extremely powerful tool to guide behavior or conduct in society, to accomplish good for the country. And it doesn't mean that there is no impunity. Some laws are ignored. But the law plays a role, even when it is not fully enforced, that is called pedagogical or exhortatory. It exhorts the people. It teaches them that in this community of ours, such and such a thing is to be rejected. And so, when the law says something, there is a value to that. In the United States of America, last year, the Supreme Court made a decision and overturned a law that had existed for 49 years. That this law was basically a decision of a previous Supreme Court in the case of Roe versus Wade that said abortion is legal in all 9 months of pregnancy. And of course, the moment the Supreme Court made that decision in 1973, the rates of abortion in America shot up more than 10 times. It was like 1,000% increase, and they have studied the way the abortion rates shot up. When the Supreme Court passed the new decision in 2022, even though some people were saying it would have no effect, the truth is that the rates of abortion have started falling in several countries because now abortion was made an issue of state rights. So the law actually has an influence. It may be gradual, but it is impactful. So we want to see what is happening in a number of countries. I'm going to look at 5 countries, case studies, and then 3 French-speaking countries in Africa. The first is Malawi. In 2015, they passed the Marriage, Divorce, and Family Relations Act. So the approach of Malawi was, can we have a general family law? And most of our countries have a marriage law or a family law that provides the different ways you can get married, whether it is statutory or civil marriage, whether it is Christian or Islamic marriage, whether it is customary marriage. And they provide which marriage is polygamous, which one is monogamous, whether polygamy is completely prohibited or allowed for certain kinds of marriage. So when Malawi was changing, repealing and replacing their marriage laws, they made it express that marriage is between one man and one woman. And they criminalized prohibited unions, ceremonies that were purporting to be marriage between people who did not have capacity to marry. So that was one approach. That was an approach where within the marriage laws or the family laws that deal with many other things, including divorce, including matrimonial property, you put in place there provisions that secure the cultural values and the family values of the country. There was, of course, criticism when Malawi did this, but like in most countries in Africa, the values that we share are upheld by super majorities of, say, 95, 97%. Even though the Western nations are critical of what is happening, the law was able to stand the test of time. The second case study is Nigeria. In 2013, under a lot of pressure from the West, the Nigerians passed the Same-Sex Marriage Prohibition Act. This was a very specific law with about 9 sections only, very specific, to deal with homosexual marriage. And in addition to homosexual marriage, it deals with associations, clubs or societies that are promoting homosexuality and any public manifestation of gay behavior. And the penalties under the Nigerian law is 14 years imprisonment for trying to do a marriage as same-sex marriage, and 10 years, a maximum of 10 years for all the other offenses of engaging in homosexual behavior. And despite the pressure that came from the West, Nigeria stood firm. The president signed the law into existence, and the West gave up on trying to overturn it. The third case study is the case study of the nation of Uganda, where we are right now. Last year, they passed the Anti-Homosexuality Act. And the Ugandan case went beyond Nigeria. Nigeria had only a small bill of 9 provisions. Uganda expanded their anti-homosexuality law. They decided to distinguish between the crime of homosexuality, you could say the standard crime of homosexuality, and the crime of aggravated homosexuality. And they said that normal homosexuality, I use the word normal, it is not found in their act. The punishment is a life penalty, and for aggravated homosexuality, which is basically sodomitic or rape. It's rape, but done same-sex, but it's violent or it is coerced, then the penalty is death. And aggravated homosexuality includes homosexuality with a child, with someone who's disabled or who is impaired mentally or physically, homosexuality that includes a parent or a repeated offender, and homosexuality that includes violence, that is gay rape. And they distinguish between homosexual act, which they say is a crime, and an alleged identity. The fact that somebody says you are gay, you've not committed an act, that is not criminal. So that appears in the Act of Uganda. And Uganda's act also prohibits extra crimes, child grooming, those who manage premises that are used for gay sex, actions purporting to be gay marriage, and also promotion of homosexuality, which is where the gay lobbies have been too much for most of Africa. They also deal with additional issues of sex offenders register, prohibition to work with children, duty to report, and the question of rehabilitation of gays. The Ugandan anti-homosexuality law was signed into law by President Museveni a few months after last year's Inter-Parliamentary Summit. And it was, I would say, one of the fruits of this conference, that even on the Friday of the conference, we went and visited the president, and we appealed to him to go ahead and sign the law, and he did. What is unfortunate is that after signing the law, several international institutions, like the World Bank, made very adverse actions and statements about revoking funding. And I felt it was a pity that Africa as a whole did not come out to stand in solidarity with Uganda, to issue statements of support, to make the West realize that on these issues, you touch one of us, you are touching all of us. And so Uganda was left almost isolated. And I think it is a pity. And one of the reasons why we are here in this conference is so that this should not happen again. Even if it is getting the speakers of our various countries, our parliaments to issue statements of support when we need to lobby our heads of states when they meet together to issue statements, and not just statements, to go into action to ensure that if the World Bank is going to deny funding to one of us on these political issues, which is even against the founding treaty of the World Bank, then all of us will take concerted action so that they know they cannot use such measures to target one country against another. There is currently a challenge in court against the anti-homosexuality law, and I think the Court of Appeal may have expressed concern about one or two provisions in the law, but most of the law has been upheld as we speak. The fourth case study is Ghana. In 2021, a member of parliament in Ghana published the Family Values Bill in Ghana. This bill was passed by the Ghana Parliament in 2024, a few months ago, I think in February this year, but the President of Ghana has not signed it into law. He is under a lot of pressure not to sign it into law from the usual suspects, and he has said that he will first wait for the Supreme Court of Ghana, which has taken up a challenge against the constitutionality of the bill. What I found interesting in the Ghanaian case is that there were 6 promoters to the bill. So individual members of parliament, many of them came together. They had a detailed and long memorandum of reasons. The typical bill has 2-3 paragraphs giving a justification. They have a number of pages. They refer to international treaties. They refer to other documents at the African level, including the African Charter on Human and People's Rights, to justify their Family Values Bill. In their bill, they include the duty to promote family values, which is yet another development that is showing how much we can get done legislatively. And they prohibit LGBT acts, they prohibit procuring, they prohibit the ones who manage premises used for LGBT, they prohibit public shows, propaganda, advocacy in support of LGBT, they prohibit clubs, and they also expressly prohibit adoption by same-sex related persons. The penalties in the Ghanaian case are mild. They are not like the ones of Uganda, for example. Their average or normal penalty in most of the bill is 3 years maximum penalty or a fine. And then in the case of the people managing premises used for gay sex, the penalty increases, minimum of 3 years, maximum of 6 years. So that is the example of Ghana. Then I also wanted to give a case study about Kenya. In 2023, one of the members of parliament who was here in the first Inter-Parliamentary Conference, Honorable Peter Kaluma of Kenya, published an anti-homosexuality bill. He later changed the name to become the Family Protection Bill. This bill has been presented to the Speaker but has not been formally received and tabled in the House. And this is quite unfortunate. Now what is happening is that the people who are opposed to family values, when they hear a sniff of a bill, they even put pressure on our institutions, on the President, on the Speaker, to try and delay the pre-publication phase of the bill. The bill has kept being improved by Honorable Kaluma. It includes a section on objects. What are the reasons for the bill to promote family and family values and other very good objects and basic principles. It has a section dealing with protection of children in educational institutions, which is one of the places where they are quite vulnerable. It talks about rights of parents in education, prohibited sexual acts. It has a section on protection of victims, disqualification of offenders from being involved in matters involving children, like children homes or education facilities. And then it also includes express limitation of certain rights. So the experience in Kenya is that sometimes the statute is deemed unconstitutional because of not being aligned with the constitution. And this happens because people take a very tortured interpretation of certain constitutional provisions. So taking that into account, there is a deliberate attempt in the bill to make reference to certain constitutional provisions, and where the constitutional provision allows for limitation, to expressly indicate the limitation and the reason for the limitation. The Kenyan case, the penalties that have been proposed are also quite tough. 14 years for normal, I use the word normal, homosexuality, 10 to 30 years for gay sex that is non-consensual, that is a form of rape. And then when it is more aggravated, it is against vulnerable persons, 25 to 30 years imprisonment. So those are some case studies of what is happening in the area of LGBT, because that is the area that has seen the most amount of legislative activity. I insist, family values is not just about LGBT. It's about protecting children, it's about avoiding comprehensive sexuality education, it's about empowering parents, and it's about strengthening families. So this is just case studies. I thought it's important I speak about a few French-speaking countries in Africa. In the case of Cameroon, because they are both English-speaking and French-speaking, they kind of like borrow from both legal systems. And their penal code was amended in 1972 to prohibit homosexuality. In 2023, through administrative action, it's not only laws, administrative action can really help in strengthening family values. Their Communication Council or Commission published some guidelines prohibiting the broadcast of homosexual content. And within 2 or 3 months, they had already suspended a broadcaster who was broadcasting homosexual content. In the case of Ivory Coast and Gabon, there is no express law prohibiting homosexual behavior, but there are laws prohibiting public indecency and public manifestation, marriage, all those things are not allowed. And in the case of Gabon, they passed a law to prohibit homosexual behavior in June 2019. And 1 year later, they repealed that law. So it shows you that it is not necessary that when the laws pass, they remain in force. Having looked at those case studies, I want to come to the last part of my presentation by reflecting on some focus areas for legislation. As legislators, as you go back to your various parliaments, what are some of the focus areas from now, May 2024, going forward? One is to deal with these issues that we have been discussing at national, at regional, and at continental levels. In this hall, you have representatives from the East African Legislative Assembly. You have other regional bodies that are able to pass treaties or agreements or laws. And all of us can influence our various heads of state and ministers and ambassadors to the African Union, so that even at the African Union level, we can try to engage on legislative and administrative measures to protect the African family. Second is we need to recognize what are the areas, the substantive areas that we need to focus on. You have the area of human rights. We have to clarify the content of human rights. when we talk about cultural neocolonialism, it is other people imposing what I call anti-values on us. We have our strong values in Africa. So we need to resist those ones by ensuring we define clearly what is the content of human rights. Areas of family and family values, there is room for distinct statutes or distinct provisions strengthening the natural family, stabilizing it. And there are all manner of ways of helping families to thrive in the 21st century. There is an area of education and health. And in this area, there is again a lot of possibility of ensuring that family values are respected. And finally, there are possibilities to have laws on culture, promotion of positive cultural values. The third area of focus for legislation is treaties. And based on the previous year's communique and protocols and the discussions that have been going on today, there has been a proposal to have a protocol to the African Charter, or maybe a full treaty of the African Union on family and family values. There is also a proposal to have a charter, not just a treaty, but also a charter, which is a declaratory statement about the African family and about family values. And there is also a proposal that at the international level, we need to work very hard towards the dismantling of the Samoa Treaty, or at least the amendment of the objectionable provisions of this treaty. So, ladies and gentlemen, these are the broad areas at which yourselves as legislators can engage to promote sovereignty, African values and family values. Thank you.